Good morning and welcome to the second day of St Philip's Insolvency Conference. Thank you for joining us. Tomorrow will be the hottest day of the year. Today is the second hottest with a sizzling talk from Chris and Rob Mundy about property interests in insolvency law. Just a reminder for those of you that have not signed up, tomorrow we have another talk by Ali Tabari and Kirsty White. They'll consider fraud in 2022, the insolvency angle. No doubt there'll be plenty to talk about there. So without further ado, I will hand it over to Chris Buckingham and Robert Mundy.
Yes, very good morning to you all. In this session, we're going to talk about four quite different situations where insolvency law and property law meet. And we've called these situations the insolvent apartment block development, which Rob's going to talk about, the bankrupt mortgage, which will be me, back to Rob for the segregated fund, and then I will finish off with the disclaimed property. So, first of all, there's Rob.
So the first scenario is based on a set of facts drawn from a handful of judgments in the last 5 years where the same problems have arisen. The situation is this. A special purpose vehicle is incorporated to build an apartment block. To raise the initial capital, the company sells the apartments off plan to overseas investors, and the investors each pay a deposit. Work begins, the company takes out a second loan from an institutional lender, the lender takes a charge over the whole site. The company then goes into administration. With the court's permission, the site is sold. The lender demands the payment of the loan. The investors demand the return of their deposits. How should the IP distribute the estate? Now, you might instinctively think that the answer to that is easy. The secured lender has security, the proceeds go to the secured lender, and the investors have, at best, an unsecured claim in the surplus. But it's more complicated than that, because when a purchaser pays a deposit to buy land, the purchaser acquires a property interest, a lien. So how do you divide the money between the creditors with competing property interests, or at least potentially competing property interests? The first case to tackle the problem head-on is a case called Easton Wong, decided by Mr. Justice Arnold in 2017. And that case concerned a student apartment block. This is what it was meant to look like. And advertised like that, the company sold around 100 suites. The investors paid 50% deposits, in total about £3 million. The company demolished the site, but then it ran into financial difficulty and the company went into administration. The investors' deposits had been insured, but the insurance company had itself gone into liquidation. With the court's permission, the company's administrator sold the site, and this is what the site actually looked like when it went on sale. Unsurprisingly, the sale did not raise enough money to pay back both the lender and the investors. But nevertheless, it sold for about £1 million. How was that million to be divided? The investors claimed that they were entitled to the proceeds, or a proportion of the proceeds under the liens. As I've said, when a purchaser pays a deposit to buy land, the purchaser acquires a property interest, a lien. And the first question argued in the case was whether the liens were enforceable. The Administrators' Council, charged with arguing the unsecured creditor's case, argued that although the liens arose, they were unenforceable because the property the purchasers bought did not exist. The individual apartments hadn't been built, that's what they were buying. Those individual apartments didn't exist, and there'd been no transfer of part of the freehold title. Well, the judge rejected that argument, and after a detailed review of the authorities, he concluded that it didn't matter that the estate did not exist. He said it's sufficient that the vendor has contracted to create the legal estate in question out of another legal estate which does exist, and that the legal estate which is to be created is identifiable. In other words, it didn't matter that the purchasers were going to buy something that didn't exist. It was enough that that part could be carved out of the freehold estate which did exist. But that led on to the second question: to what do the liens attach? The judge's answer to that was that the liens attach to the area of the land which is the subject matter of the contract, the area of land which is the subject matter of the purchase contract. Well, the upshot of that is, if you contracted to buy the flat I've highlighted in red, then what you end up with is a lien over this airspace. And what you logically end up with are a number of liens attaching to different airspace. So if these 5 flats I've highlighted in red were sold, then you get liens over 5 different portions of airspace. That's all well and good, but how then should the proceeds of sale have been divided? The individual parts of the airspace weren't sold separately. The whole site was sold for £1 million. How much of the £1 million should go to the investors? How much of the £1 million should go to the secured creditor? Well, there was no secured creditor in Easton Wong, so in Easton Wong, how much should go to the unsecured creditors? The judge answered that question by looking at the value of the flats to be built as a proportion of the value of the entire development. That was a complicated exercise. First, the judge considered the basement and concluded that the basement could be ignored because it was to host plant to service the entire block. And although he didn't say so expressly, so too, presumably, the other common parts. Now that left the ground floor and the apartments. The ground floor was to be used for a number of shops. The judge thought that on the evidence, or on the lack of evidence, the shops had no value. So he ignored those 2, and that left the apartments. Most of them had been sold, but not all of them. So he divided the value, the £1 million or so, value of the site between the apartments that were sold and the apartments that were unsold. For the apartments that were unsold, the proceeds would go to the unsecured creditors. For the apartments sold, the proceeds would go to the investors. That decision goes a long way to answering our problem. But our problem had a complicating factor. In our problem, the company had granted a charge over the whole site in favour of the lender. How does that affect the equation? Well, just that problem arose in a case called Birch and House Limited. That was a project to turn a tax office and hotel in Birkenhead into luxury apartments. The background was similar. The company sold a number of apartments to investors. This time, though, the company granted a charge over the entire site. The company then sold some more apartments to investors, and so now we've got proprietary interests that compete. A purchaser might have a lien over part of the building, but the charge holder had a charge over the whole building, the whole space. How did the judge deal with this problem? How were the funds to be distributed? Well, the first thing the judge did was work out the order of priority for the liens and the charge. And essentially this turned on the date of registration at the land registry. The liens registered at the land registry before the charge was registered had priority over the charge. The judge called those Category A purchasers. But the charge had priority over the liens registered later. The judge called the liens of the Category B purchasers, and the liens that were never registered at all, the Category C purchasers. What then did the judge do? Well, again, the judge divided the value of the entire site between the various parts, attributing the value to the apartments in proportion to the value that they would have when they were sold. When they were intended to be sold, was complete. The value attributed to the apartments bought by the Category A purchasers went to the Category A purchasers. Then the value attributable to the unsold apartments went to the secured creditor. The value of the apartments bought, the proportion of the value attributable to the apartments bought by the B and C purchasers went to the secured creditor, and then would have gone, if there had been a surplus, to the Category B and C purchasers. There have already been several cases that follow Easton Wong and Birch and House, and no doubt there'll be yet further cases that will have to tackle this problem. So perhaps it's an interesting one to know about.
Thank you, thanks Rob. So moving on to our second situation, the bankrupt's mortgage, and it's one that it is likely to be quite common. There might be a jointly owned property held by partners, one of whom is made bankrupt, but the other partner carries on paying the mortgage. And what I'm going to do is examine various situations in which this might arise and the likely outcome. But the key principle that is likely to be in play here is the doctrine of equitable accounting. And that can be summarised, or is summarised, in Snell's Equity, described as being the process by which financial burdens and benefits of land shared by co-owners are adjusted between them, often but not always by way of division of the proceeds of sale. This process is distinct from an inquiry as to the extent of the parties' respective beneficial interests in the property. So the first sort of mini situation is this. The mortgage is in joint names, property is in joint names, and it's beneficially held 50-50 by the two partners. And the question is, what effect do those payments have on the account to be taken? Now, it's likely that the remaining party who discharges the entirety of those payments would be entitled to a credit as against the co-owner or the estate. And that is a basic application of equitable accounting principles. And the factual scenario, which in fact arose in the case of Gorman, shown on the slide there, the payment of instalments due under the mortgage operates to relieve the property from the charge and gives rise to an equitable right of contribution by the co-owner who has not paid his due proportion of the instalments. A slightly different situation is this one. Again, the mortgage is in joint names, but the property is in the sole name at law. In my view, this really makes no difference. The primary inquiry is as to beneficial interests. The property may be in joint names, it may be in a sole name, there may be an express declaration of trust, or the court may in fact find that a constructive trust has arisen. And in the case of Wilcox and Tate, it was said that questions of equitable accounting only arise once the extent of the party's beneficial interests has been determined, since the requirement to account, where it exists, is a reflection of and derives from those beneficial interests. So if the property is in the sole name of one partner, but the beneficial interest is split due to either an express declaration of trust or a finding of a constructive trust, and one partner shoulders the burden of the entire mortgage payment after the other's bankruptcy, on the face of it, again, there would be a right to a credit. Now, most of the reported cases, in fact, concern properties which are jointly held at law. The case of Solomon and McCarthy, an unreported county court case, was a sole name case, and the claim for an equitable account was in fact rejected, but on the basis of a lack of evidence rather than the fact that the property was held in a sole name. A twist on the previous situation is this. Again, the mortgage is in joint names, the property is in the bankrupt's name, but beneficially it's held by the bankrupt and the bankrupt alone. Now, I have to say this is a pretty unlikely scenario, unlikely in that if the mortgage was jointly held, it's probable that the beneficial interest would be split as well. But it's doubtful in that situation that equitable accounting would be very much assistance. In the 2017 case of Davis and Jackson, it was said that technically any credits should probably only commence from the date of the relevant trust deed, which conferred a beneficial interest, rather than the date on which a property had been purchased in a sole name. The implication being that absent that beneficial interest, matters of equitable accounting simply don't arise. However, there is the possibility that the partner who had been paying the mortgage could establish an interest, not by way of equitable accounting, but by mortgage subrogation. That is a remedy to reverse unjust enrichment. To establish such a claim, it would need to show four things as set out in investment trust companies. Has the defendant been benefited in the sense of being enriched? The answer to that is probably yes, the mortgage has been paid. Second, was the enrichment at the claimant's expense? Again, probably yes, the claimant has paid it. Was the enrichment unjust? Well, this requires identifying a recognised unjust factor, and if a surety pays a debt, they have a right to an indemnity against the principal debtor as part of the law of unjust enrichment. And fourth, are there any defences? Well, probably not. The fourth and final little situation that I want to look at is this. The bankrupt's mortgage, or the mortgage is in the bankrupt's name, the property is in the bankrupt's name, and beneficially it's held by the bankrupt as well. Nevertheless, the non-bankrupt partner takes it upon himself or herself to pay the mortgage. In my view, equitable accounting is unlikely to be of very much assistance at all here. The absence of a beneficial interest is problematic, but also that it would struggle to establish any sort of subrogation claim. The only possible remedy I can see is an argument made on ex parte James grounds, and there is an old case applying that principle called enrichment. It doesn't concern a mortgage, but rather payments made on the life policy of a bankrupt by the wife of the person who was made bankrupt, and essentially the court held that it would be really contrary to natural justice not to allow the paying wife to have the benefit of that policy. So that is my second situation. I'll pass back to you, Rob.
Well, you may be familiar with this third situation where property and insolvency law interact. I've called it the segregated fund, but what I'm talking about, of course, is the quis-closed trust. The basic idea is relatively straightforward. A pays money to B. A and B understand that the money is to be used for a specific purpose and understand that it's not to be at B's free disposal. And until quis-closed trust idea is that until B uses the money for that purpose, the money is held by B on trust for A. And as we know, that has important consequences in insolvency law. Typically, A has agreed to lend money to B. Although A has agreed to lend money and the money is in the bank account of B, until B uses that money for the stated purpose, A is, in equity, still the owner of the money. A has a proprietary interest in the money better than that of a secured creditor, so far as A is concerned. So far as equity is concerned, A is the owner of the money. Let's look, though, at a couple of examples from recent cases and see how the theory is applied in practice. So cases, each of them with a little twist on how the quis-closed trust arguments arose. The first is a decision of Mr. Justice Pepperell, formerly of these chambers, in Deluxe Properties Holdings and SCL Construction Limited. Well, the facts were straightforward. Deluxe had engaged SCL to carry out building work. SCL charged 20% VAT, and SCL accounted to HMRC for that VAT. But it turned out VAT should not have been charged, and so SCL applied for a refund. HMRC's policy was not to pay VAT refunds where the customer had been charged VAT unless the customer was to be repaid. And so SCL undertook that it would refund its customers, principally Deluxe, and that it would not use the credit for any other purpose. When SCL was on the verge of going into liquidation, Deluxe, the customer, sued, arguing that the credit, the VAT credit, was held on trust. Was the money held on trust? Yes, said Mr. Justice Pepperell, there was a quis-closed trust. The payment made by HMRC was for the sole and express purpose of allowing SCL to reimburse the mistakenly charged VAT to Deluxe, and was clearly intended to restrict SCL's freedom of disposal. so that the credit was to be exclusively used for the stated purpose without settlement. So HMRC A pays money to be used for one purpose, and it's clearly understood that the money is to be used exclusively for that purpose, in this case HMRC to SCL. The twist in this case, one of the interesting points that arose from this case, was whether Deluxe had an interest in enforcing the trust. The claim was brought not by HMRC but by Deluxe. Typically, when a quis-close trust is created, when it's created, the property is held on trust for the payer. A pays money to B for a purpose. B holds the money on trust for A, even if the purpose is to pay money for C. The money is initially held on trust for A. But Mr. Justice Pepperell said, if C is told that the money is being held for it, then that can amount to an assignment of the beneficial interest in the money to C. And that's what the judge said that had happened in this case. Because SCL had told Deluxe that it was going to receive money on its behalf, that perfected the assignment of the money, that perfected the assignment of the proprietary interest from HMRC to Deluxe. Another example, this time from the New South Wales Supreme Court, case from this year. The case concerned two companies associated with the family of Ken Rosewall, who was described by the judge as an Australian tennis player, famous Australian tennis player. I found out he'd won several Grand Slams in the 50s and 60s. One of the companies, Fakema, orally agreed to lend the other, BBY, 3 million Australian dollars. BBY was a financial services business and wanted the money to meet a margin call. But the judge found BBY did not tell Fakema that this was the purpose of the loan, just that the money was to deal with a problem with a certain trade. The judge found BBY did not promise to use the money only for that purpose, and did not promise to keep the money segregated. Was there a quis-close trust? No, concluded the judge, Justice Gleeson. For there to be an agreement that the money would be used for a specific purpose, obviously both parties had to know what the purpose was, and on the evidence that test was not met. One of the interesting features of this case was how the question arose. Typically, questions about quis-close trusts arise where the lender wants its money back and is worried that the money will be distributed otherwise to creditors. But here, the lender had received its money. The $3 million had been paid back. What happened was that the receivers and managers of BBY challenged that payment back as the payment of an unfair preference. Fakema, who'd received it, argued that the repayment was not an unfair preference because the $3 million was held on quis-close trust for it. In other words, Fakema argued the money had always belonged to it. BBY had not paid any of its own money, so it can't have paid an unfair preference. The argument didn't succeed on the facts because Fakema didn't establish the quis-close trust, but conceptually it's a sound argument, and in the right case a good defence to a preference claim might well be that the money was held on trust and therefore never belonged to the company alleged to have paid the preference. Okay, I'll hand back over to Chris for our final scenario.
Thanks, Rob. So just briefly, I'm going to be talking a little bit about disclaimed property. There are two very well-known situations set out on this slide. One, disclaimer of owner's property by a liquidator under section 178 A of the Insolvency Act, such property vests on a vacantia in the Crown. Although in the case of freehold property, it's in fact escheats to the Crown, which is principle set out in the well-known case of Skimler Properties and Gesso. In the second situation, when a company is dissolved, property is deemed to vest on a vacantia. Section 1012 of the Companies Act 2006. The Crown may, of course, disclaim that property which vests in it, Section 1013. And in the case of freehold property, that has what is sometimes described as a boomerang effect, because it in fact comes back to the Crown, albeit a slightly different part of the Crown, as an escheat. It's also quite well known that in each of those two situations, it's possible to apply for a vesting order pursuant to specific statutory provisions. In the case of the Insolvency Act, it's possible to apply under Section 181. And in the case of the Companies Act post-dissolution, it's possible to apply for a vesting order under Section 1017. But I want to look at a couple of twists on the basic, the obvious factual scenario. One is where the property is in fact held on trust, because properties held on trust are expressly excluded from the scope of Section 1012 of the legal title isn't determined, but beneficiaries may apply to a different route for a vesting order by the Trustee Act, specifically Section 44, and join the Attorney General as a defendant. The course adopted in Restructuring was exactly that. This was an interesting case in which three shareholders had decided that their company would be wound up and certain properties that it held divided amongst them. There was, consequent to that, a special resolution recording that agreement and winding up the company. Unfortunately, after dissolution, it was discovered that there was a failure to convey those properties, and an application was made pursuant to Section 44 of the Trustee Act, and in fact another provision in the court held that given that agreement between the shareholders, the company ought to be regarded as having become a trustee, and it was accordingly appropriate to make a vesting order under Section 44 of the Act. Another situation which arises from time to time is that of the option. In the case of UBS Global Asset Management, the claimant sought to exercise an option to purchase a freehold granted by a BVI company, but discovered, again, rather unfortunately, that it had been struck off the register and dissolved. Now, the court held that it didn't vest bona vacantia in the Crown under Section 1012 of the Companies Act because the property had been held by an overseas company, rather it escheated straight to the Crown. So the next obvious thing to consider was Section 44 of the Trustee Act, which we've just looked at, but that was inapplicable because the mere grant of an option didn't give rise to a trust applying previous authority. Instead, the court exercised its powers, little known, under Section 181 of the Law of Property Act, to create a legal estate and vest it in the claimant's company. This decision was then applied in the later case of Quadricolor Limited and Crown Estate Commissioners, where in fact the dissolved company was an English company rather than overseas, but the Crown had disclaimed any interest it had prior to the claim having been brought. And again, property disputed, and relief was given under Section 181 of the Law of Property Act, rather than either the Trustee Act or the Companies Act. And so what is this Section 181? Well, I've set it out there in full. It states that where by reason of the dissolution of a corporation, either before or after the commencement of the Act, a legal estate in any property is determined, the court may by order create a corresponding estate and vest the same in the person who would have been entitled to the estate determined had it remained a subsisting estate. So it's rather a mouthful, but it is quite a clever little device that can be employed in these sort of rather tricky situations. So there we have it. That concludes substance of what we had to say this morning, but I believe there may be a few questions.
Yes, you're right, Chris, there are a few questions. Right, let me get through these. So first of all, I've got a question for Rob. Rob, you mentioned in Easton and Wong that the administrators needed the court's permission, or they obtained the court's permission to sell the apartment block. Why was that needed?
An administrator can't sell property which is subject to a security without either the consent of the security holder or the permission of the court. And the problem you had in Easton and Wong, and it's common to nearly all of the cases that have followed it, is that there are just so many of the purchasers potentially with purchasers' liens. And in Easton and Wong, like many of the cases, many, if not all of the purchasers are overseas. So the administrator simply had a practical problem that they couldn't get the consent of all of the security holders, all of the charge holder and all of the lien holders as well.
I see. Okay, so I've had a question coming from Lisa. Thank you, Lisa. Could you talk about what happens when investors have paid in instalments over time? Are they caught by the purchaser's lien? They are not strictly deposits. If they are caught, what if the loan and the security were entered into and then some more instalments were paid? Is there an order of priority based on when the monies were advanced or paid? Or do the A purchasers have priority of the secured lender for all of the sums they're paid, even if some of those sums were paid after the security was given? It's not quite one question, really, so I think that's 6 there, but if you can get the gist of that, Rob.
Well, goodness. Well, I have to say that's not a problem that's discussed in any of the authorities that I've read. I think instinctively I would think that the answer to the first question would be that the purchasers would have liens, because I don't see why it should make a difference whether the payment towards the purchase price is described in the contract as being a deposit or not. So if payments have been made over time, then I should think that liens would arise. The second question is a tricky one. When do they have priority? And there's no, well, I think that's a tricky one, because there's no doctrine of tacking. It would seem inconvenient if every time the purchaser made a new payment, they had to register a fresh lien at the land registry, but that might be the answer, I'm afraid. I think that's a difficult one.
Thanks, Rob. Jan's asked a question on the issue of interest in property not being disclosed to the trustee in bankruptcy. Let me just read that question. Suppose the bankrupt fails to tell the official receiver or the trustee in bankruptcy of his interest in the property, sole or joint interest, until post 3 years from the bankruptcy order. When the trustee in bankruptcy discovers it, has the vesting in the trustee in bankruptcy occurred on the bankruptcy order or the date he discovered the asset? And what duty does the trustee in bankruptcy have over the newly discovered asset, e.g. public liability claims before and after he learns the asset? Very specific question, that, Jan. I wonder if you should be getting advice from counsel. But, let's see if Rob or Chris indeed can assist.
Well, I think it vests on the bankruptcy order rather than it being discovered. It's possible, I think, to obviously to apply to suspend the discharge. It's also possible, I think, to extend that period of time. What happens if there's been a failure to disclose and three years have expired? I'm not absolutely sure. I don't know whether you.
It's not a problem that I've come across before. No. So I'll pass on that one. I'm afraid.
Yeah.
If in doubt, Jan, always instruct counsel. We have a number of people, I'm sure Justin will tell you, from our chambers that can probably assist. Right, Jan's obviously had a week to fix you. There's another question been put in. In the previous section, so I think this is a reference to Rob's talk, but I might be wrong. In the previous section, your panelists said that categories B and C would get the surplus after the charge. However, category C were the unregistered liens property purchasers. Would they be treated as unsecured creditors?
No. The lien is created. Purchasers' liens existed long before registration at the land registry. The lien is created when the money is paid towards the purchase price. When, in our case, the deposit is paid. Registration at the land registry then protects the priority of that lien as against other secured creditors. So in the Birch and House case, we had category A who were registered before the charge. Then the charge was registered. The charge then had priority over anything that comes subsequently. Category B was registered, and then finally category C was unregistered. Well, those liens still exist, they're still enforceable, but if another charge were then registered, that charge would then have priority over the category C liens. But no, they are not the same as unsecured creditors. The payment of the deposit creates the security interest, and the registration simply protects its priority.
Thank you, John, for those two questions. I've had a question here from Helen. Can you provide further insight into when the court would be willing to apply equitable accounting over principles such as constructive trusts?
Yes, indeed. So the fundamental point is this, that it's really a two-stage process. First, to ascertain the equitable interest, and it might well be that property been bought in sole name of husband or wife, but the court finds, applying back down and so on and so forth, that there's a 50-50 equitable split, but then husband or wife, for whatever reason, usually bankruptcy, takes it upon himself or herself to pay all of the mortgage instalments. And the point of equitable accounting is that at that stage, the court really steps in and says, well, hang on, even though there's a 50-50 split at stage one, there should be some adjustment via the process of equitable accounting to compensate the partner who effectively has overpaid as compared to what he or she would be expected to pay, looking at the beneficial interest. So it's really an exercise to be applied often post-bankruptcy, because one of the partners has overpaid compared to what is fair. And if there wasn't some compensation, then in substance, the estate would be enriched at the expense of the partner who's taken it upon himself or herself to bear the burden of the entire mortgage. So that's the point of the exercise, and it's at that second stage that it would come into play.
Thank you, Chris. I've had another question from Chris, not this Chris, some other Chris. Could the early repayment of an unsecured bounce-back loan by an insolvent company within the preference period prior to liquidation or administration be defended by the recipient using a quis closed trust argument? Rob?
I don't see any reason in principle why it shouldn't, because it would depend on the terms of the loan, and potentially also whether the money was segregated by the borrower. That's also an indication as to whether the parties have agreed that it's to be used for one purpose and not to be used for any other purpose. I don't see any reason in principle why a bounce back loan can't be a quis closed trust, and therefore whether repayment of it it isn't a payment of the company's own money, but it would be the exception rather than the norm.
Would it make a difference, Rob, if there was no specific purpose to the bounce back loan? As I understand it, it was liquidity provided in the coronavirus, but it had to be used for a particular purpose. Would that make a difference?
So again, you've got to look not at the commercial purpose of the loan, but the purpose of the loan as agreed between the parties. Now, in the case of a bounce back loan, that's going to be a written contract. So you're looking to the question of whether the written contract limits the purpose for which the loan is to be used. So in your example, where the parties might have in mind using the money for a particular purpose, if the terms of the loan agreement allow the money to be used for general liquidity purposes, then you don't have a quid pro quo trust.
Super, thank you, Rob. Right, a very easy question from Lynn. Lynn's asked, can the slides be provided afterwards, please? Rob?
Yes.
Rob's done all of the organisation, all of the superb technology behind the scenes, so that's your answer, Lynn. Final question here from David. Does equitable accounting only apply to mortgage payments made post-bankruptcy?
I see that's Mr. Smiley. A very clever question. It's in fact two questions.
Two questions.
One is whether it simply applies to mortgage payments. I think the answer is no. The case of Solomon, which I referred to earlier, albeit unsuccessful for evidential reasons, didn't concern mortgage payments at all, but concerns alleged payments to improve property, and that didn't seem to be a problem. The second element is it only post bankruptcy. No, in theory. In practice, virtually all the cases do concern and arise out of bankruptcy situations. So, in theory, it would be possible to argue that there's a need to go through the equitable accounting process. Pre-bankruptcy, it is very rare as a matter of practice.
Super. Thank you, Chris. Thank you, Rob. So, unless there's any further questions and none flashing up, I'd like to thank Rob and Chris for their superb talks and also for answering all of the questions put forward by the participants. And thank you, the participants, for joining us.